Yes, the broadcast will be back in 3, 2, 1.
Продовжуємо засідання.
We continue our session.
Прошу запросити наступного
Let's
кандидата,
invite
Makaryk
the
Ihor
next
Volodymyrovych.
candidate, Makaryk Ihor Volodymyrovych.
Доброго дня.
Hello.
Розглядається питання щодо відповідності
We are looking at the issue of compliance of the candidate for position of judge of HSC Makaryk Ihor Volodymyrovych with criteria envisaged by Part 4, Article 8 of the Law of Ukraine on High Anti-Corruption Court. Here we have representatives of the PCIe, Robert Heinberg-Heisen, chair of the PCIe, Norman Alves remotely, Makaryk Butler remotely, Gabriele Jodkart-Granskian, Jessica Thompson, John O'Sullivan, and we have also Mikhail Lebanis, Vitaly Gatsenyuk, Юг, Надія Кабецька, Ольга Колеш, Ігор Кушнір,
Руслан Мельник,
Мирослав Мельник, Олексій Милян, Андрій Пасічник, Руслан Сидорович, Сергій Чумак, Галина Шевчук, members of the HQCJ. You have a right to submit recusal applications, submit applications, express concerns, objections, or challenge decisions of the Commission as envisaged by legislation. Do you have any recusals? No.
дякую.
Thank you.
Доповідачем з цього
The
питання, член комісії
rapporteur
Шевчук.
of this candidate, we have Ms. Galina Shevchuk. Please, Madam Shevchuk, over to you. Thank you. By the decision of the HQCJ on 16 September 2025, Mr. Makaryk was allowed for participation in the competition. By the decision of the same commission as of 2025, there was also a decision on assessment of Mr. Makaryk knowledge, and with the decision of 4th February 2026 of the Commission, general results of the first stage of the qualification exam were adopted, and Mr. Makaryk Ihor Volodymyrovych was admitted for the second stage of this process, the interview itself, and based on the result on general legal knowledge test and specialized legislation, Mr. Makaryk has got 148 points. Based on the results of the Ukrainian statehood exam, he has got 40 points, and cognitive test has brought him 42.26 points. And for practical assignments, Mr. Makaryk has got 130.5 points. General score of Mr. Makaryk 366.76 points, and Mr. Makaryk has received his education in Ivan Franko National University of Lviv, and he received Master of Law in 2013. In 2012, he received Bachelor of Law. He has worked as a Chief Specialist of the State Registration of Property Rights Department, Registration Service of the Ternopil City Department of Justice from 2013 to 2015. Starting 2015, he has been working as a legal counsel of the Legal Department, LLC, Trade and Production Company, Persha Privatna Pravarnya, for people as for yourself. He has worked with this LLC. In 2017, he has received an attorney license. He has professional experience as an attorney, including for representation in court of interests of his clients for more than 7 years. He has proficiency in Ukrainian language. He has submitted 3 declarations: family ties declaration, integrity declaration, and declaration of a person who is obliged to carry out functions of the state. During this preparation for this interview, the Commission has sent requests for receiving information to different authorities such as NACP, NABO, National Police, State Border Guard Service, OPG, and other service authorities. That's all. Thank you. Mr. Robert, over to you.
Thank you, Mr. Chairman. Good afternoon. I would like to pass the floor to our rapporteur, and that's Mary Butler. Mary, are you there on the screen? Can you see Mary Butler there on the screen?
Yeah, I can see her. Hello.
Thank you. Yes. Can you hear me? Can you hear me?
Yes.
Okay. Mr. Makaryk, thank you for your cooperation in this important process. It's my understanding that you have applied for a position of local court judge and for the High Anti-Corruption Court. So it seems clear you would like to be a judge. Can you tell us why you want to be a judge of the High Anti-Corruption Court and how you see that responsibility as different, if you do, from the local court position?
Дякую вам за запитання.
Thank you for your question.
Стосовно того, можу повідомити вам,
Regarding it, I can give the following information. Indeed, I submitted my application for participation in the competition for position of a judge, for general specialization and administrative specialization, and also commercial specialization. But the latest one, because of my personal reasons, I was unable to come to tests, and that's why my participation in that competition was terminated. And also, now I'm participating, and actually I'm already allowed for participation in the specialized administrative court competition. But I would like to say from the beginning that this high anti-corruption court is the most important for me, and this competition is the highest priority for me. And I will tell you why. Indeed, I stand for my state, and I'm very responsible and careful in looking after all the processes that are happening, both in terms of the judicial reform and generally, and how our state tries to be a member of European legal family. I would like to contribute to it in terms of administering the justice. My motivation to be a judge, it has not just appeared or 7 years ago when the High Anti-Corruption Court has been established. Yes, of course, it's clear that I wanted to become a judge, but no one was thinking about such high anti-corruption court to be established in the past. Speaking about your question, specifically about this responsibility issue, I see it as the following. In the high anti-corruption court, I will have much higher workload in comparison with the general court or local court or administrative court. And there also the workload also will be higher in comparison with specialized administrative court if I succeed in that competition. But the High Anti-Corruption Court, it already keeps working. It already keeps administering justice, and it has been working since 2019. It's already a working team of judges who have already been working there, and I can learn a lot from them. I try to develop myself professionally. I try to develop myself in different legal areas. I try to demonstrate to this commission that I can administer justice in different courts under different specializations, and maybe even in different instances. If we're speaking about the High Anti-Corruption Court, of course, I'm aware that there will be certain pressure. Potentially, there could be certain political pressure. But here, sitting in front of you, I'm not afraid of the issue of my integrity, because at my work, at my professional activities, I always complied with integrity principles. I was always open, honest and transparent in interacting and cooperating with everyone. There was no single sign of behavior from my side that could inflict a shadow at my professional activities. And I think that it will be the same in future. Independent on whether I succeed or not in this competition, I need to say that I'm going to develop myself further in the area of law. I keep working for the justice in our state to become even better. I just want you to listen to me, to believe in me, to trust me as a potential judge of High Anti-Corruption Court. Thank you.
Thank you. And I understand that after your time in the Ministry of Justice in Ternopil, you began to work as an in-house lawyer for a large corporation in Lviv. Did you also represent other clients as an attorney?
Так, звичайно, представляв.
Yes, of course, I represented.
Other clients, not just your employer.
Так, звісно, ця
Yes,
інформація
yes, of course. This information is available in my dossier.
And yes, some of these questions are for the benefit of people who might be watching online or following online. So in your experience representing private clients, have you had cases before the High Anti-Corruption Court or involving NABU or the Special Anti-Corruption Prosecutor's Office?
Ні, ніколи таких справ не
No,
було.
never. I never had such cases.
Have you represented clients in where they were the subject of criminal investigations?
Так, на досудовому
Yes.
розслідуванні
At the pre-trial investigation stage, I was the defense attorney regarding trial proceedings that was cooperation of several defense attorneys, maybe even defense attorneys engaged in individual entrepreneurial activities and law firms. And because of procedural issues related to the remote location of courts, I performed intellectual work, while representation services were provided by other defense attorneys with whom the client had respective agreements, and they were representing their interests in courts directly.
So, do I understand you to be saying that you are not a person who has experience representing clients before courts in court?
Ні, неправильно ви розумієте.
No, not correctly. I have experience of representing interests of clients in courts, of general local courts, administrative courts, commercial courts, as well as having experience of defending against criminal proceedings at the pre-trial investigative stage.
Is there anything about your experience as a defense attorney that you think that we should know about because it might reflect on your ability to serve on a high anti-corruption court?
Скажімо так.
Let's put it that way. I cannot say what can make the Commissioner or the PCIe some concerns regarding my candidacy. I have defended the interests of clients as I have done. I believe that I did that within the framework of the Criminal Procedure Code, and I always responded properly within the framework of the current legislation to specific events happening while representing the interests of my clients.
I see from your material that at one point you rented an office or premises from your employer. Can you tell us why you needed to rent a separate office from your employer?
Дивіться, я фактично
Look,
продовжую.
actually, I continue renting it. I believe that if I had been engaged in some activities as an attorney within the framework of activities at my main place of employment, I think it would look a bit lacking integrity. Then I was the initiator to conclude this agreement, and I concluded this rent agreement with my employer, basically. And I can say even under some beneficial terms and conditions. It's related to the fact that I indeed engage in legal work there. And I am forced, I have a need to keep some attorney's documents, some dossiers, if I had been doing that somewhere outside of the office where I'm all the time, basically, because I live at work. It could cause some questions and questions from the PCIe as well. So, under these circumstances, these agreements were concluded and were implemented.
Can you tell us, is your wife engaged in the practice of law?
My wife is a doctor. She was a therapist, and now she is the cardiologist starting from February 3rd of 2026.
And I understand that your father is a retired appellate court judge from Lviv. Is that correct?
Так, вірно.
Yes.
Is there
Correct.
anything about his service that someone could allege reflects on you negatively if you were to serve in the High Anti-Corruption Court?
Мій батько працював
My father worked at the position of the judge at first of the district court, started from 1993 until 2011, as far if I remember correctly. Then he passed exams with the Higher Qualification Commission, and after that he became a judge in Lviv, Lviv Administrative Court of Appeal. Then in 2018, my father also passed exams, and he was transferred within the framework of the judiciary reform. He was transferred to the 8th Administrative Court of Appeal. Due to some events that were related in particular to his poor health condition, he had COVID in 2021, and he retired because of that. Throughout the period of his work, my father had never had any reprimands, and once he retired, there were no disciplinary proceedings. He had no disciplinary sanctions ever. Throughout the period of his work, he was always administering justice properly. I'm proud of being my father's son, and I'm proud of having someone who can help me and tell me some information that maybe I would not have been able to obtain without having any experience of working in the court. And apart from representation of my clients in court, I have never worked in court. I never worked in the court apparatus or as an assistant of the judge or as the secretary of court hearings. In this context, I believe that that's even positive, that I continue the history of my father, so to say, and I want to say that I will do that with honor in the High Anti-Corruption Court as well, if I have this opportunity.
And one last question. Could you please describe the source of funds for the purchase on June 30th of 2022 of an apartment in Lviv of approximately 57 square meters?
Так, звичайно,
Yes, of course.
я з задоволенням
I will gladly tell you about that, because there is no secret here. In 1994, I will go from afar. In 1994, my father received an apartment as a judge, and he privatized it free of charge. It happened in 1994. Then, accordingly, this apartment was with the area of 40 square meters, and it was this apartment was privatized actually in the name of three persons, three family members: my father, my mother, and I. Back then was 3 years old. Subsequently, my sister was born, and then there appeared some questions and issues about maybe selling that apartment and buying an apartment with a bigger area. So this way, my father entered the share participation, I think, in the year of 2000, and it was investment into the construction of an apartment, and he registered the right of ownership for that apartment in 2010, if I'm not mistaken. That previous apartment of 40 square meters where we lived, with my participation, because I was a co-owner of that apartment. It was sold. I consented for the sale to the upbringing body. This body asked my opinion whether I agree to the sale of that apartment. After that, I actually, because of my studies, I stopped being a family member of my previous family, so to say, and I started accumulating funds since the moment of my university studies. I was accumulating funds, of course, in a very difficult way, so to say, because my salary was not that high after graduation from the university. At the same time, I got employed after civil service. I started working as the legal counselor, and starting from 2017 or 2018, my salary significantly increased. I could accumulate more savings this way. Also, I would like to say that some funds for the purchase of the apartment that you're asking about was also provided by the parents of my wife. With respect to my wife's parents, right now I have to say the amount. They gave 6,000 euros to us. These funds were transferred in foreign currency. They gave these funds to my wife. They assured my wife that there are no supporting documents. They did not provide any documents. They explained to my wife that these were the funds saved by them throughout the entire period of their employment, and they used to work abroad as well. My wife's father used to work in Portugal and Sweden, and her mother worked, if I'm not mistaken, in Italy. These funds were transferred to my wife, and they also became a part of those funds that we used to buy the apartment. Moreover, I requested help from my parents because we still were lacking a substantive amount. And my parents, using their family savings, also gave us a share of the funds so that we could buy this apartment. In 2022, the full-scale aggression of the Russian Federation against Ukraine started, and we were deciding as to what we were going to do, where we would live, how we would live, and it was decided we were looking for an apartment, and it was this search was very long, frankly speaking, because before then I rented in the same multi-apartment homeowners association. So I rented an apartment in the same residential complex where we lived together with my wife. Sorry, Mr. Ihor. Can you be more concise, please? Yes. So the apartment was bought by us using my savings, using savings given to us by my wife's parents, and as well using savings given by my parents.
Thank you. I don't have any further questions.
Thank you, Mary. Any of my colleagues have questions? John? Yeah, I do have a question, if you don't mind. When I look at your profile, and I may be wrong, I see someone who has, and you said that yourself as well, has no experience at all in a court. You've never been a judge. You have never educated anything, and you work in a beer factory. That's the position, isn't it? And of course, I respect and understand that you want to become a judge, and that's a very good thing if you want to achieve that. But my question would be, why do you want to start in the High Anti-Corruption Court, which is a very important court, where there should be judges who know what they're talking about, who have seen the judiciary in and out, who we are certain that they are competent and they have full integrity. And I don't doubt that you have full integrity or that you are very competent, no doubt. But clearly, not having any experience or background, why do you feel that if you would be elected in the Hague, the High Anti-Corruption Court, that you would be someone they should have? Should it not be much more wise that you start to be first a judge and that you learn judging? Because many judges, it takes years before they are, let's say, really competent and well-established judge. I don't know the other jurisdiction, but if you want to be a judge in the Netherlands, you need at least 6 years of training. And you would come from a beer factory and just become a judge. And I find that very strange. So can you reflect on what I've said?
Так, дякую за запитання.
Yes, thank you for your question. Your question is well understood, and I will answer it as follows. The High Anti-Corruption Court is a very important court for our country. I believe that I have some primarily professional competencies, and I'm able to contribute something to this court from me. As an attorney, I work all the time with a huge amount of documents, different documents, including financial documents. I work with documents of financial monitoring. I also have experience of providing legal assistance during declaration processes. I also have experience of working, as I mentioned in my responses to the questions of the Public Council of International Experts, and I have this experience of working in criminal proceedings, which could corruption criminal offenses, which are determined by the Criminal Procedure Code as corruption offenses. Look, the fact that I do not have experience of being a judge, in my personal opinion, is my advantage. Maybe I will be able to look at some criminal proceedings from a new perspective, because I have some experience in the taxation law, in labor law, and in the civil law, and I have experience in the sphere of intellectual property. And I think that this experience that I have will allow me to be more effective and more thorough in investigating evidence. I also believe that I have a range of soft skills, personal competences that will allow me to effectively administer justice in the High Anti-Corruption Court. In particular, I can say that I'm very thorough in my approach to the evidence and to proving. I analyze the evidence well. I quickly and deeply, in my opinion, think analytically. I also have probably to say that I observed and followed activities of the High Anti-Corruption Court since the moment of its establishment. Basically, since the moment when the first verdict was adopted, which was quashed through the appellate chamber of the High Anti-Corruption Court because of the decision of the Constitutional Court. I'm also following hearings of the High Anti-Corruption Court all the time. Since I'm working in Lviv, I cannot physically represent some clients in the High Anti-Corruption Court. However, I would like to say that for sure I would do that. Also, I would like to draw attention to the fact that candidates like me, of my age, there was already a precedent when they became judges, including judges of the appellate chamber of the High Anti-Corruption Court. For example, I can provide an example of Mykola Glotov. Also, candidates of my age right now are finding themselves. They have to contribute to judicial institutions. They have to bring fresh blood and fresh visions. Maybe we have a slightly different approach, even to the reforming of the High Anti-Corruption Court. We all know that the High Anti-Corruption Court is right now adopting and administering justice in cases on sanctions. I cannot agree.
But it's clear that you think that, what your opinion is, that you have sufficient background to become a judge. But if I listen to you, I'm wondering whether you consider being a judge is something that you need to learn, or that you have acquired that by birth, or because in many countries, I repeat myself, it's a job that you're not suddenly qualified to do. You have to, let's say, take lessons. You have to look at other people doing it. Your judgments have to be checked by more experienced judges. You have to learn how to write a judgment. You have to learn how to do a court hearing. And in my experience, it's not so easy. It's difficult. In any case, I found it difficult, I'm sure. Gabrielle found it difficult because she is a long-standing judge. About John, I'm not sure, but I'm quite sure. It took a bit of time before he became a judge. And when I listen to you, you say, well, I'm very good. I have the abilities. If you make me judge, I will do well. But if you're realistic, you still have to start your career in the judiciary. So maybe you can reflect on what I say again. A bit short, maybe.
Не. Звичайно, я це обов'язково прокоментую.
Yeah, of course, I will comment upon it, and I will even comment it from that perspective that I also wrote it to PCIe. You know, such certain recommendations that allegedly I don't have a relevant experience to carry out to administer justice in the High Anti-Corruption Court. These are recommendations of the HKCJ were provided by the National Anti-Corruption Bureau of Ukraine. But regarding this, I would like to say the following, that maybe the NABU first doesn't have such authority to give such recommendations. I think that independent High Qualification Commission of Judges and independent Public Council of International Experts using my dossier and information which I'm trying to present to you right now shall make their own conclusions regarding my experience. Secondly, I would like to say that my results, even in comparison with other colleagues on producing, writing procedural documents and rulings as a judge of the appellate chamber, let's be open. My results were better than results of colleagues who have been working for 7 years, almost 7 years, as judges of the High Anti-Corruption Court. So it means that they, having certain experience and knowing their own practice at their courts, and actually High Anti-Corruption Court has not made so many verdicts. They have made, it has adopted only 300 verdicts. So I think that they shall know it by heart, because they have been working since the very moment of establishment of this court. But at the same time, my results were a little bit better. I think it could also be an evidence that, yes, I'm capable to work as a position of a judge of the High Anti-Corruption Court or its appellate chamber. Thank you.
Okay, thank you, Mr. Chairman. I have no questions at this moment.
Дякую. Колеги, Галина
Thank you,
Миколаївна.
dear colleagues. Let's start. There will be a few questions, maybe follow-ups questions. First of all, question to you regarding renting premises for your activities. So you've expressed this information that there was some certain discount provided to you. Look, what do you mean here? Look, please. So we are limited in time. How much time do I have? Please be concise. In a nutshell, to understand the essence. So I work at the industrial site. No. What the discounts were provided to you regarding renting of that premises? I think that that's a discount for price of a working place of a lawyer. What's the discount? 1,000. 1,000? What's the area of this premises? Look, no. Roughly 49.1, because this premises consists of several rooms. Okay, clear. So it means that for 1,000, is it possible to rent premises in Lviv for work of an attorney when you pay 1,000 hryvnia? As far as I remember, and I looked at the interview of HKSJ, no, we are not speaking about interviews. Okay, other attorneys, they have relevant agreements, and for the same price, they rent their own working places as attorneys. Regarding my situation, no, I asked you, please give me a reply. No. Please listen till I finish. You interrupt, you don't listen, you don't have patience to listen. You are at the interview, just listen to what I'm telling you. Do you know the renting price in Lviv of roughly similar conditions? Is it possible to rent such premise for 1,000 hryvnia? Yes, it's possible. It's possible. Okay, thank you. Next question. Have you defended relatives of your employer at the court? Have you represented their interests at court? Relatives of your employer. So relatives. Okay. Let's go name by name. At court, you represented interests of Matsola S.A. and Matsola B.N. Maybe these are relatives of your employer or founders. Yes, they are relatives and founders. Okay, tell me, what were conditions for you representing their interests? No, without any introductory words, just reply. Pro bono. Okay, pro bono. All my activities I carry out pro bono. I mean, all my attorney activities I have been doing it pro bono, and I think that I will do it till the end of the martial law. Okay, clear. Are there any relatives of your employer who are socially unprotected persons that you carry out such pro bono activities? I think that no. Is it possible to establish any kind of connection between the fact that employer provides to you rent of large premises, extremely large premises, I think, as for work of only one attorney, because you don't have any hired employees, and the fact that you defend interests of his family pro bono? I think that no, and I will explain why. The renting agreement was concluded in 23rd December 2021, if I'm not mistaken with the date. At that moment, I had not carried out any such kind of representation or defense. Okay, no. Don't continue. So then, the next question. As you are applying for the judge of the Higher Anti-Corruption Court, do you see here any potential conflict of interest in this case? Conflict of interests? Definitely not. I don't see. Conflict of interest, that's contradiction between certain authorities of a person and certain their activities in terms of presentation. Then I will reformulate my question regarding the code of ethics of attorneys. Do you see any conflict of interest here? Is it normal to represent interests of relatives of your employer? Would it cause any concerns from the side of external observers, the public? Does it raise any doubts in your, so let's say, professional activities? Look, at all my professional activities, I always tried to act with integrity. Yes or no? I think that no, but I would like to explain why. May I? Yeah, of course. And I would like the respected public and the PCIe to understand that I was thinking how to extend my attorney's practice. I have also discussed it with my wife, but because of certain events, including introduction of the martial law, together with my wife, we have discussed this issue. I receive certain official income. I receive salary. It's not a small one. It allows. Can you be please more concise with your position? Look, you're speaking about your in relation with your wife, your family budget. We are not asking you about this. We don't need to show your relation with your wife for the public. Please, about you, about your pro bono activities, and the fact that in your declaration you reflect only your income on activities related with maintaining functioning of this enterprise as a lawyer there, but you do not reflect any income as attorney. I think that all clients could confirm it because I have never, yes or no? Only yes. So it means that attorneys' activities, it's like some kind of your hobby because it doesn't bring you any income. All my work, all my life, legal life, I think that it's hobby. It's my work from the bottom of my heart. Okay, clear. Then tell me, would you consider also this work in the High Anti-Corruption Court as hobby? Of course, no. Because you have submit application for the commercial court and high anti-corruption court, and in another competition you're participating. So where do you see yourself? I have answered this question to the PCIe. I see myself as a judge, even of maybe of the appellate chamber of the high anti-corruption court, from the perspective that because of my qualities, from the professional perspective, I'm capable to carry out revision better. Thank you. I've got your point. Tell me, please. In your motivation letter, when you submitted documents, you mentioned that you always strive for improving your qualifications, strengthen your knowledge in the legal field. Tell me, please, how? When we actually have no information about how you have improved your qualification as an attorney. We have only information regarding 2018, 2019, that you have improved your qualifications. That's all. Thank you. Thank you. Information regarding improvement of my qualification, I submitted, and it's reflected in my attorney's profile. Since 2019 to 2025, what I can tell about 2026, I have already, since 2019, 2018 to 2025, tell me, at least what kind of workshops or trainings relevant to the activities of High Anti-Corruption Court that you have taken? Yes, of course. I have taken participation in workshops on implementation in practice of the law on prevention of corruption. It was back in 2019. The similar workshop was, or conference maybe, was attended by me in 2021. This year, 2026, on 3rd of February, if I'm not mistaken, I have already participated at the workshop on procedural guarantees while considering cases in absentia. And I think that Anti-Corruption Court works a lot with such categories of cases in absentia. Okay, thank you. Thank you. I'm just asked you the names of workshops. Thank you. Provided detailed answer to these questions, and maybe my colleagues will have some questions to you. Hello, I'm Kolush, Commission member, and first of all, I would like to clarify what normative act regulates criminal corruption offense and the notion of a criminal corruption offense. So such notion is envisaged in note to Article 45 of the Criminal Code of Ukraine. Thank you. Thank you. Thank you. Yeah, you have mentioned the Criminal Procedural Code, and that's why I have asked this question. Maybe you just made mistake at that moment. Okay, thank you. Based on your motivation letter, you say that reason for participation in this competition for the HACC judge was adoption of the law. The law making amendments to carrying out pretrial investigation, etc. But tell me, how the position of the HACC judge is correlated with adoption of this law, and how you would have been able to impact on it. No, I didn't mean that. I didn't mean that, and I will try to explain it right now. What I meant there, I meant the following, that for the public and also for myself, the anti-corruption sphere is crucial. In any way, I'm aware that the key goal of the HACC judge is to be independent and impartial in administering justice. They do not fight corruption. They are not an authority which fights corruption. But I wanted to show the importance of and the goal of those reforms which take place also in the area of functioning of the High Anti-Corruption Court. That's why so you didn't have any reason of adoption of this law for participating in this competition. So that's the difference between reasons and preconditions, because my country is important for me, and indeed I want to live an independent, sovereign, legal, free country, and I think that the judge is the synergy, the quintessence of all legal terms, processes, and all legal opportunities. And when you administer justice on such a high position, for you and on your shoulders, there will be huge responsibility. And I think that I'm capable to take such responsibility. I want to take it on my shoulders, and I want to make my contribution indeed for us to join the Western European legal family, for us to be accepted there as on equal terms as a partner. Okay, tell me, thank you. Tell me, in which countries of the European family they have anti-corruption courts? Anti-corruption reform has taken in Romania. In Romania, they have some nuances, some specifics. Okay, in how many countries of Europe they have anti-corruption courts? Maybe I didn't dig into such details in how many countries. So you want to contribute your knowledge and skills in order for Ukraine to join the European family. So then you shall know the stories, this history of European family, the history of anti-corruption authorities of the European family countries. Yeah, I've got a question. I've got a point. Okay. And maybe I will answer in such a way. Starting 1990s, Ukraine has signed different... No, I didn't ask about Ukraine. No, I know. You asked about European legal family. But if we want to join it, I want it in how many countries of Europe there are anti-corruption courts. I mean, current anti-corruption courts that are functioning now, as of now. Courts and judges which carry out justice in corruption cases in each country. Okay, clear. Thank you. Thank you. Let's go to practical questions. So, for example, you have been appointed as a judge, you administer justice, you consider cases on application of sanctions, and your decision on introducing of sanctions is challenged. What will be your actions?
To me, as a judge of the appellate chamber of the High Anti-Corruption Court, and do you see yourself as the judge of the appellate chamber of the High Anti-Corruption Court? Okay. Let's imagine you are a judge of the appellate chamber of the High Anti-Corruption Court. Probably I will deny in satisfying this motion because the law determines a specific period of time that is a bit shortened for consideration of these cases. If I'm not mistaken, it's considered for 30 days by the first instance court and 15 days by the appellate chamber. And the ground for denying in satisfying the claim would be the term. The ground for denial will be that the legislation does not envision the possibility to terminate it. The legislation, but that's the Code of Administrative Judiciary Proceedings? No, the law on sanctions. And what about the Code of Administrative Judiciary Proceedings? Does it envision this termination? As such, are you going to consider this motion based on the law on sanctions or the code? The code, of course. So, according to the Code of Administrative Judicial Proceedings, can it be terminated? No. Thank you for your answer. And I have one last question to you. You have given comments about decisions written through your practical assignments by other judges. From the perspective of the Bangalore principles and the Code of Judicial Ethics, can a candidate for the position of the judge? And by the way, I would like to remind you that you are also subject to the requirement to comply with judicial ethics. So, can a candidate, and a judge even, criticize decisions of other judges, even if this is a virtual decision during a practical assignment? No. Decisions of other judges cannot be criticized. In this case, I was trying to show that I'm capable of administering justice in this court, in particular, while comparing me to other candidates. And I was comparing my candidacy. And accordingly, one of the Bangalore principles is diligence and competence. And I believe that this principle is also the one that should be applied. Among other things, during preparation for participation in the competition by all candidates. Thank you for your answer. I have no more questions. Thank you. Mr. Mikhailo, please. Thank you. Mr. Ihor, I would like to discuss with you the constitutional duty regarding military service and the duties related to this. In June of 2025, the Commission has announced the competition for filling in vacant positions of the High Anti-Corruption Court, right? And deadlines for submission of documents were established. And it started since July 7th of 2025 and until August 6th of 2025. And I would like for you to complement information that we can see in your dossier. In your dossier, you say that on July 28th of 2025, that is during the period of submission of documents for participation in the competition, you got a document that confirmed your military registration. And on July 28th of 2025, that is actually on the eve of the date when you submitted documents, you got the status of the person who is deferred from conscription. And the date on that deferment from conscription is July 28th of 2025. I would like for you to explain which what military duty you had before that, how you fulfilled your military duty, and can you tell us in more detail about the rest of this military registration document and the status of the person deferred from conscription? Can I provide a more extensive answer? Well, let's be concise. Please answer these three questions that I've just mentioned, and that will be enough. Look, my status has not changed since I graduated from the Academy of Land Army, and I got a military specialty under the investigative and prosecutorial work in 2012. I was registered with Lechakivsko-Shevchensky Center of Lviv. After that, in connection with the change of the place of registration, in August of 2013, I got registered with Halitsko-Frankivsky Military Conscription Center of Lviv. Then, due to the reforming, I remained registered with Halitsko-Frankivsky Territorial Social and Recruitment Center, and my status of a person bound to military service has not changed. Starting from 2024, since summer of 2024, I have had the status of the person deferred from conscription due to my employment at the enterprise. I would like to draw attention to the fact that I prepared a new military registration document through Reserve Plus app so that I could submit it in the package of documents for participation in the competition for the High Anti-Corruption Court. And as you are saying, on the eve of submission, this information was updated. But if you look at my military registration document that was submitted in the competition process, I submitted the documents as soon as I could do that. That was on March 1st of 2025. And if you look at military registration documents, you can see that it was also prepared on the eve of that date. And that military registration document also shows that I had the status of the person deferred from military conscription. I am bound to military service. My military registration data were updated on time. While maintaining my integrity and decency, I, among other things, addressed the Territorial Recruitment Center with a request to get military registration due to the fact that I changed the actual place of residence, because I was registered in one neighborhood of Lviv, but actually right now, due to the purchase of the apartment, I have lived in another neighborhood since 2022. That's why I addressed Halitsko-Frankivsky Territorial Recruitment Center of Lviv, and they orally told me that I did not have to do anything, that I was lawfully registered with them, and that I didn't have to do anything. Okay, understood. I would like to clarify. The status of the person deferred from conscription, when did you get it? In summer of 2024. What was the ground? Deferment from conscription. In which enterprise? In the enterprise where I work, at my main place of work. Okay, thank you. Position, lawyer of the legal department of LLC, Persha Privatna Pravarnya, for people for themselves. Deferment from conscription was given due to the fact that the enterprise obtained the status of the critically essential enterprise for economy. This status was confirmed in 2026 by order of the Ministry of Economy dated February 9 of 2026. Thank you. During the period from February of 2022 until the moment of deferment from conscription in 2024, you were bound to military conscription. So, in order to fulfill my military duty, I addressed the Territorial Recruitment Center, asking whether I had to get a new military registration. I got a response that no, that they did not have any questions about me as the person bound to military service, and I left my contact details with the Territorial Recruitment Center, and that's it. Thank you. Do we have any other questions? Yes, please. Today, during the interview, you have repeatedly mentioned about your qualities, which, in your opinion, give you some advantage. You also describe them in detail in your motivation letter as well. Given that among my qualities and values, which will be advantages for the work of the judge, I have disciplined nature, thoroughness, patience, persistence, decisiveness, etc. Of course, quite difficult to check these qualities. But in the context of that, I would like to ask you, have you studied the explanations of the NACP thoroughly while filling in the declaration? You filled in only 3 declarations. During period of 2022, 2023, 2024, the website of the NACP has lots of explanations. Have you studied them? Yes, of course. I even understand the question that you are going to ask. Can I comment on that? Well, it's good that you anticipate what I'm going to ask you. You even have this quality. But I would actually like to ask, in questions and answers during communication with the PSC, you also had a question about declaration of the apartment as joint ownership. You explained in detail. Again, you're referring to the NABU, that the NABU did not take into account provisions of the family code. And you are confirming that according to the family code, this apartment is owned under the right of joint ownership. That's why I drew attention to that. Maybe you did not read the explanations of the NACP that well. Please pay attention for the future if you are filling in declarations in the future. And there, in clause 68 of the explanations, it clearly stipulated that it is necessary it is necessary to declare information only about the main title owner. Thank you. That's a comment from me. Okay, thank you. Can I comment on that? Let's put it that way. I've looked through these explanations which were updated. They were updated after I had submitted the declaration in January of 2022, if I'm not mistaken. And yes, indeed, maybe based on my example, even these explanations were updated. And actually, you're right that it is said there that it is necessary to declare only the title owner. You provided, you gave answers to questions of the PSC. You gave these answers like just recently, but I was filling in the declaration before the explanations had been published. Okay, colleagues, do you have any other questions? Yes, please. Mr. Ihor, tell me, please. I have 2 questions to you from different spheres. One is similar to the question of the co-rapporteur from the HQCJ about this office that you are renting. Tell us, please, isn't this low rent amount unofficial condition of the employer that you will be the attorney of the family and that you will be providing pro bono services to family members of your employer? Because frankly speaking, there might be such perception that the explanation for this low rent amount, because we see these causal links, and we were discussing them today. I would like to repeat my question. Wasn't it the condition for this low rent payment that you would be providing pro bono legal services to family members of your employer? Or do you consider it to be, even if yes, and even if no? Briefly, concisely, please, just in up to a minute, tell us, please, do you consider it to be some violation if it had been like that? Thank you for your question. No, I do not believe that the agreement between me and LLC Перша приватна броварня for the rent of the office was concluded with the signature of the director of the enterprise. Information about him is stipulated in the Unified State Register of Enterprises, and he has powers to conclude such agreements. With respect to the representation of interest of those persons that you are talking about, they were not involved in any way into the conclusion of this agreement. That's why I understand that this question might arise, but at the same time, please also pay attention to the fact that I am providing legal assistance based on the same conditions without any privileges or limitations to other individuals and legal entities as well. Mr. Ihor, thank you. I will continue my question. Tell me, please, do you really believe that that's the question about honesty? Do you really think that you can be believed when you are saying that family members of the owner of the enterprise where you work accidentally addressed you with a request to provide legal aid? Of course, they chose you from all the lawyers of Lviv, and they chose the one who works as a lawyer at the enterprise owned by them. Of course, they did not come to me accidentally. That's really true. I cannot deny obvious things. They know that I engage in attorney's activities. They know that I'm doing that on specific conditions. They also understand that maybe I also need some experience even in different categories of cases. And under these conditions, the persons came to me. I provided respective legal aid. I believe that I provided these services in a quality manner. You've answered. Accidentally, not accidental because they know you. Yes, of course, they know me. Okay, thank you. Let's continue. With respect to skills and knowledge that will help you to work in the High Corruption Court, I would like to ask some questions as well. Without disputing your scores for practical assignments, I read your practical assignment, and what I was surprised by is that, frankly speaking, both assignments are not that huge. There are no 10 episodes, no organized criminal groups. Well, like that's the first instance, and the appellate where we know. And we try to make decisions readable. Comprehensible to people. And I was interested as to why you produce such long decisions. I understood why for myself. Like the Criminal Procedure Code, where we have the content of the verdict, just one of the examples as to why you have such an extensive and long decisions, which are quite difficult to read. 23 pages, and that's one small episode. That was a mistake about the declaration or some failure to the declaration, and 23 pages of the court decision that you prepared. And here it is said that in the verdict, it is necessary to mention circumstances that usually takes like 2 sentences, 5, 6, up to 10 lines for mitigating circumstances. And it took you 3 pages. Why? Because you are just copy-pasting the criminal code. Why? Why are you doing that? Why are you completely quoting the article with all the circumstances, subclauses, and that you are not using it at all? While the article does not impose this duty on you, you have just to specify these circumstances. Why are you copy-pasting the criminal code on 3 pages?
Look, I cannot recall my memory as a practical task itself, but I want to pay attention that decisions, rulings, and other resolutions of the judge of HSC shall be an example of justification and reasoning. And the reasoning is based on what evidence the decision is made. But the decision or verdict shall be motivated. So it means that the judge shall give details why such decision was made, specifically this decision. And when when I carried out that practical task, I tried to motivate it, to justify it from different perspectives in order for an external observer, a grader who is going to check my work, to have indeed trustworthy image of myself, that indeed I carry out diligent and appropriate examination of all circumstances, and I pay enough attention to each of them, because there are very different issues, from my colleagues regarding first instance. I'm sorry, we have some, period of time limit for your interview. The question was very simple. Why, if the CPC requires to mention circumstances which actually exaggerate or simplify station, but you quote all circumstances and potentially could be applied, but not applied directly. Why you should do it? And why, in a simple case, you just increase it up to 23 pages, I didn't think that it's too many pages, because verdicts in anti-corruption cases could actually be up to 100 pages, and they describe in detail. Sorry, Mr. Ihor. Sorry for interrupting. I just want to correct your reply, because you do not reply to the question. The question to you was very clear, and you are telling about other verdicts and being asked you about your work. So what was the purpose for you to quote fully the criminal procedural code, when it envisages that you need to mention only those circumstances and that aggravate or vice versa, not aggravate station? Why do you do it? No, I don't do it. I just tried to use at my own discretion those provisions that I thought necessary to apply. It was not done with the purpose to make my answer more complex or more difficult to read. No, I thought that it was an appropriate range to reply to this task. Thank you. I have a short question. Indeed, as it was mentioned already before many times, that this candidate has a limited period of experience in criminal justice. And as our topic of our interview cannot be related to specific competences of functioning of the HC, but my question is the following. Please tell me, what's the difference between the assets could be subject of civil confiscation and assets that under article which envisages criminal responsibility for illegal embezzlement? Civil confiscation envisages that the amount from 750 to 3,000 of subsistence minimums for working age persons. And for criminal responsibilities, this is another amount. And regarding other proceedings, so they could go in parallel. So proceeding against the person in no way means that there shall be no proceeding against an asset. And it means that anti-corruption court can handle those proceedings in parallel, but mainly that's the size of the asset. Thank you. Tell me, please. So let's call it civil confiscation. So yes, this term is not used by legislation, but it's quite widespread in practice. So the civil confiscation term, could it be considered also under criminal proceeding? Please repeat your question again. Is it possible for a term, civil confiscation, and the issue related to civil confiscation and complaint on confiscation of motivated assets, could it be subject of consideration with criminal proceeding? Yes, it could be. And I have just mentioned it. I have just mentioned that proceedings against the person and against an asset, they could go in parallel, they could be considered in parallel within the criminal proceeding. Look, for example, the criminal proceeding is regarding a person, and the person is accused in illegal embezzlement. Within this criminal proceeding, could we consider also the case of civil confiscation? No, it's considered under a different code. So we have criminal procedural code and civil procedural code. So these are two different codes. And the task of the High Anti-Corruption Court is to administer justice. That's criminal proceedings, that to carry out control over pre-trial investigation and relevant authorities. And also there are other tasks as to recognize assets as unjustified assets, and also another separate task, which I think shall not be a task of the HCC, that's sanctions. So, to my question, you gave two different replies, which are absolutely contradictory. What of your replies is the right one? So, two different proceedings. So, my question, within the criminal proceeding, is it possible to consider the issue of civil confiscation? What's your reply? My reply, no. Thank you. Thank you, dear colleagues. I have also one question, and I hope that's a short one. During an interview, you've mentioned that you represented interests mainly of your employer where you work, but if I got you right, you also represented interests in different court litigations of other legal and physical entities. Can you give us a rough number for the last 5 years? So, from 2020 to 2025, what's the rough number of the legal and physical individuals to whom you provided services per year? The number or the names? The rough number. So, speaking about enterprises, I think that's roughly about 10, 12 per year. And what about individuals? Individual-wise, if we take also family and civil cases, maybe about 20 per year. So it means that from 30 to 40 subjects, both legal entities and individuals, received services from you per year for the last 5 years. Yes. I look at the certificate, tax certificate regarding your income. And for these years, there were mentioned only 3 or 4 entities or persons who paid money to you. Explain why. So I will explain. No, I don't need you to explain us the nature of the origin of such income. No, not about it. Why? In this tax certificates and reports, they don't have any information regarding those 30 or 40 entities or individuals to whom you provide services. Because I provide my attorney's activities pro bono. And in those cases, these were legal fee, legal services fee, which was paid during the whole period, and I provided relevant information to it. So the tax information includes all information about you, both as private entrepreneur and as a lawyer. And for these years, they contain information only regarding three entities or individuals who paid to certain remuneration. Yeah, obviously for provision to them of legal support. So I can imagine that does it mean that all other 30 entities or individuals didn't pay to you anything? Yes, you're right. Even to them, I provided support pro bono to a certain extent. But those subjects, no, I've got your point regarding those subjects. They paid to you your services and it reflected in this tax reports. But I don't get regarding others, because you mentioned that each year you provided services to roughly 30, 40 entities or individuals per year. So it means that either you have not received any income at all from those services, or you did provide information to the tax authorities, or maybe there is another option which I don't see, and it's not that obvious. Yeah, it's obvious actually. That's what I mentioned to the PCIe. And so what I'm explaining to you, I provide these services pro bono. I provide the support pro bono, free of charge. I think that's a right of each person. Yeah, it's obvious. That's commercial relations. Each of us, we independently decide how we provide them. What's the reason for it? My reason is to get experience. Good. You know, another reason, another motive that in Ukraine we have been entered into martial law, and that's what interrupted me. I wanted to tell you that together with my wife, we decided to all together that during the martial law, all my attorney's activities shall be provided pro bono, including to service persons, and also veterans or decommissioned military. But we mentioned also that you provided support to legal entities. Why did you provide to legal entities pro bono support? Because I provided pro bono. Yeah, that's a fact. But I'm asking about motives, reasons, because as a rule, of course, it's your right to do it. But as a rule, lawyers, legal specialists, they provide services and in return they receive some payments because they need to support their families, to support their livelihood. So why did you do it? What's your motive? What's the reasoning of your decision? So it's interesting for us, you know. I am happy that I'm not a standard candidate for the position of HT judge, and I like it so. Yeah, it's in return, it's the same for me. And again, I would like to tell you very openly, frankly, you can ask any of my clients that indeed they didn't pay any money to me for receiving from me legal professional support as a lawyer, as an attorney. Okay, that's a fact, but I asked you about your motives. Thank you. Okay. One more question to follow up this topic, maybe the last one from my side. So you've just mentioned that you want to gain experience, you provide support for quite many enterprises. But what about your employer? Does your employer give not enough workload to have so much free time and provide support to other entities? And it does not, impact negatively your employer, and it's also, and you provide all support pro bono, and all people come to your employer. Who you mean? Which people? My clients? Yeah, my clients. I provide to them my support at my place where I work, and it does not impact on your work as a legal counsel. As a legal counsel, yes. So I've got your question regarding this. I would like to inform you the following. We have certain working schedule, and I work from 8:30 to 5:30 as a legal counsel with a 1-hour lunch break. I don't procrastinate during my work. I try to do it very strictly, in an order, gradually, and day after day, regularly. I have provided, and I am providing right now, legal support to other legal entities. Those legal entities, if it's necessary and when it's needed, indeed come to me, to my working place where I work as a lawyer. And actually, my room is less than 49.1 square meters. And that's why these premises were rented for the purpose of negotiations. Sorry, this you are replying in so extended way and not by the essence. You know, the Commission is capable to differentiate when you reply to our question or when you deviate. Just give a strict reply. I don't remember, for example. So my work as a legal counsel, I have enough of it, more than enough. And after 5:30, I'm physically capable to carry out additional working activities. Yeah, colleagues. So we are beyond our timing, but the last question. Yeah, thank you. Sorry, it's important. Mr. Ihor, look, on 6 December 2023, the Chief District Court of Lviv has adopted additional decision where you represented interests of complainant and defendant, that's the LC organization, and that's about 5,000 of hryvnia, which shall be paid on the benefit of the complainant, and this complainant then paid it off to you. But in the tax reports, there is no information about such 5,000 hryvnia. Can you explain the situation? Yeah, I can explain. That's commercial proceeding. No. That's Kyiv District Court. Yes, okay. Look, Tov Omar, where I had some relations with. The contract was terminated, no money was paid, and relevant documents are available, and the agreement was terminated. Sorry, please listen to me carefully. You know, I think that I'm asking a question in normal Ukrainian language. Please listen carefully. So it was the case by complaint of a physical person. 2. So complaint against LC Omar. According to court decision, you were a representative of a complainant. So you reached out to the court, and I'm reading out right now the court decision. You replied to court through the electronic judicial system with an application to compensate your legal professional activities and in the amount of 5,000 hryvnia. And this money shall be paid from the defendant towards the complainant whom you represented. And then the agreement on provision of legal services concluded on 1st September 2023 between the complainant and lawyer Makaryk, not Omar LC, but complainant and you. So, and then the receipt that the complainant paid to you 5,000 hryvnia. And this amount was actually taken from the Omar LC. So either you submitted to the court a fictitious doctorate document that you have received 5,000 hryvnia from the complainant, or you were not frank and honest with us that you provide completely pro bono services. And that's one of the court decisions. Court decisions available in the court register, where it specifically says that complainant paid to you 5,000 hryvnia, but in the tax reports there is no information regarding it. And I can give you the number of the decision 446885523, 6 December 23. Can you tell me the name of complainant? No, I can't tell you. You know, I don't. Again, I'm open and responsible in my answer to you that all my attorney's activities have been provided pro bono, free of charge, and all my profits are reflected in the relevant information owned by the tax authorities. Maybe in that moment, maybe money were not paid, or they conclude that the agreement was terminated and money were returned back to the complainant. I just can't recall in my memory who was that case about and who was that complainant. You know, I just provided legal support in several cases where the defendant was this organization, this LC. So it could have been such a situation when money should have been paid according to the agreement, but such money were never paid. And maybe, sorry for interrupting you, The question was asked to you by Sergei Yurievich, referring to a receipt, which shows that this sum was paid to you. What are you talking about? It's a terminated agreement, non-paid sums? No. The question was specifically, as it was not mentioned in your declaration. Am I right? Yes. And there is a reference to receipt which confirms payment. So either this receipt is doctorate one or the court. So if the candidate say that maybe this money was not paid to him, and why there was an he approached actually to the court to pay this money to the attorney. Regarding it, I want to mention the following: that the civil procedural legislation allows to take remuneration for legal professional aid when money is not paid yet, but maybe it should have been paid according to the contract. And maybe it was such a situation that after the professional legal aid was provided, the contract on provision of professional legal aid was terminated, was cancelled. So, and I'm responsibly telling you that all my income and paid and accrued taxes and those and that income were which I reflected as a subject of declaring process. All income was declared. All this has been declared. So I declare the whole income, and the declared income is reflected for the period from 2017 to 2023, I think. I have provided this information in different attachments to Public Council of International Experts in reply to their questions.
Mr. Ihor, I think that it's clear, especially that, as you are saying, you gave answers to these questions to the PCAE. We will look through them, of course, again, just for a clear understanding of the situation. Colleagues, no more questions? Dear members of the PCAE, maybe you have some additional questions.
I'm just looking at my colleagues.
Yeah.
No, not on this side, Mr. Chair. Thank you.
Добре.
Okay.
Пані Мері, Норман.
Madam Mary, Norman,
Нема питання, бачу. Гаразд.
no questions. Okay.
Пане Ігоре, вам надається можливість...
Mr. Ihor, now you have an opportunity to address us with concluding remarks if you want to say something and if you feel the need to do that. But if you want, please be very concise. Thank you. Thank you, dear members of the Public Council of International Experts. Thank you, dear members of the High Qualification Commission of Judges of Ukraine. Thank you for organizing this competition that I really could get here to you objectively, impartially, independently, based on my own efforts. What I would like to say? I would like to say that I want for you to believe in me as the judge of the High Anti-Corruption Court, so that you see in me opportunities, that you see in me the desire to work, that you see in me that I really, throughout my entire career, I always engaged in legal work. I have different experience. I have experience in justice bodies. I worked with materials for official use. I also worked with we know about that. We've looked through your dossier and with your autobiography. Yes, and I would like to say that in any case, no matter which decision you take, I understand that maybe my experience looks a bit minimal for you. Maybe you might think that it is not suitable for the High Anti-Corruption Court. But I responsibly would like to say that I'm developing myself. I would like to say that any procedural moments in which I have some gaps. Maybe I can master them. I have physical capacity to process lots of analytical, financial documents, taxation documents, which would result and which would directly impact the quality of justice administration in the High Anti-Corruption Court. And this skill is obtained throughout the entire lifetime of the person. Thank you. And I have this skill. Thank you. Thank you. Thank you for your participation in the interview. Thank you for explaining your positions. Colleagues, I'm announcing the interview with the candidate over, and I'm announcing a technical break now.